Another day, another story. Of the right of private defense. Section 96. Things done in private defense. Nothing is an offense which is done in the exercise of the right of private defense. Section 97. Right of private defense of the body and of property. Every person has a right, subject to the restrictions contained in Section 99, to defend, first, his own body, and the body of any other person, against any offense affecting the human body, secondly, the property, whether movable or immovable, of himself or of any other person, against any act which is an offense falling under the definition of theft, robbery, mischief or criminal trespass, or which is an attempt to commit theft, robbery, mischief or criminal trespass. Section 98. Right of private defense against the act of a person of unsound mind, etc., when an act, which would otherwise be a certain offense, is not that offense, by reason of the youth, the want of maturity of understanding, the unsoundness of mind or the intoxication of the person doing that act, or by reason of any misconception on the part of that person, every person has the same right of private defense against that act which he would have if the act were that offense. Illustrations: A. Z, under the influence of madness, attempts to kill A. Z is guilty of no offense. But A has the same right of private defense which he would have if Z were sane. B. A enters by night a house which he is legally entitled to enter. Z, in good faith, taking A for a housebreaker, attacks A. Here Z, by attacking A under this misconception, commits no offense. But A has the same right of private defense against Z, which he would have if Z were not acting under that misconception. Section 99. Acts against which there is no right of private defense. There is no right of private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt, if done, or attempted to be done, by a public servant acting in good faith under color of his office, though that act may not be strictly justifiable by law. There is no right of private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt, if done, or attempted to be done, by the direction of a public servant acting in good faith under color of his office, though that direction may not be strictly justifiable by law. There is no right of private defense in cases in which there is time to have recourse to protection of the public authorities. Extent to which the right may be exercised. The right of private defense in no case extends to the inflicting of more harm than it is necessary to inflict for the purpose of defense. Explanation 1. A person is not deprived of the right of private defense against an act done, or attempted to be done, by a public servant, as such, unless he knows or has reason to believe, that the person doing the act is such public servant. Explanation 2. A person is not deprived of the right of private defense against an act done, or attempted to be done, by the direction of a public servant, unless he knows, or has reason to believe, that the person doing the act is acting by such direction, or unless such person states the authority under which he acts, or if he has authority in writing, unless he produces such authority, if demanded. Section 100. When the right of private defense of the body extends to causing death, the right of private defense of the body extends, under the restrictions mentioned in the last preceding section, to the voluntary causing of death or of any other harm to the assailant, if the offense which occasions the exercise of the right be of any of the descriptions hereinafter enumerated. Namely, first, such an assault as may reasonably cause the apprehension that death will otherwise be the consequence of such assault. 29. Secondly, such an assault as may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such assault. Thirdly, an assault with the intention of committing rape. Fourthly, an assault with the intention of gratifying unnatural lust. Fifthly, an assault with the intention of kidnapping or abducting. Sixthly, an assault with the intention of wrongfully confining a person, under circumstances which may reasonably cause him to apprehend that he will be unable to have recourse to the public authorities for his release. 1. Seventhly, an act of throwing or administering acid or an attempt to throw or administer acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such act. Section 101. When such right extends to causing any harm other than death, if the offense be not of any of the descriptions enumerated in the last preceding section, the right of private defense of the body does not extend to the voluntary causing of death to the assailant, but does extend, under the restrictions mentioned in section 99, to the voluntary causing to the assailant of any harm other than death. Section 102. Commencement and continuance of the right of private defense of the body. The right of private defense of the body commences as soon as a reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense, though the offense may not have been committed, and it continues as long as such apprehension of danger to the body continues. Thanks for watching.